US literature on the Lawrence case, it's very clear that people who are on record as opposing the decision in substance are very, very keen on voicing their opposition in the language of the Supreme Court has gone too far given its place within the Constitution. And I suppose the ultimate expression of that is Justice Thomas's dissent within Lawrence, where he says, if I was a member of the Texas state legislature, I would vote to repeal this law, but since I'm a judge in the Supreme Court, I can do nothing about it. And of course it begs the question how far the substance is really driving the procedural concern. And I suspect a similar question could quite properly be raised about the judgment of any Supreme Court around the world, including that of the Supreme Court of India in Naz.
I think I saw a hand up.
To Ma'am Saunders. Did I spell it properly? Is it okay? So my question is, comparing laws between two nations, it's actually being a creative idea, and you know, exchange of ideas between nations, to laws of between two nations. I think it's particularly give a lot better growth to a laws when you say it in context of, let's say, in the intellectual property laws or arbitration laws. But wherein in constitutional law, it's the birth of the constitutional law is itself in a very, it depends upon the social perspective, and the demographic and the lot of the factors that's helped to build a constitution of that country. So all I'm saying is, isn't it not correct that let the Indian constitutional law takes its own growth, its own time, not according to what the other nation of the country is taking its own changes. So am I correct? My views are correct?
Well, yes and no. I mean, you're quite right that all the original literature about the problems of transplanting laws from one jurisdiction to another, much of that was developed in the context of private law. And those theorists, people like Kant, Freund and Watson, specifically said, we're not talking about public law, that's very difficult, that's very embedded in context and history and local politics and so on. All of that's true. We know that it's hard to do comparative public law, but we also know that it is going on all the time. Every constitution in the world today, with the possible exception of those two early sort of founding constitutions, are influenced by other constitutions. Judicial reasoning, whether the judges own up to it or not, draws upon world experience. So we've got to be conscious of this is the reality, and frankly, just doing stuff within our four walls, to use the once Singaporean phrase, will make us very parochial and cut us off from a whole lot of really interesting ideas. The challenge for us is to do it consciously and properly.
Isn't the affecting the core idea of itself the core idea of what the Constitution was developed?
Not necessarily. I think you can have your cake and eat it too if you do it properly.
I think we have a question here now.
Good afternoon. I have a question for Tarun. It's an excellent presentation. My reaction is, what about self-conflict in discriminatory regime in Indian Constitution? For example, if you look at only on the ground of or on any of them, the phrases in Article 15 and 16. Secondly, what about the particularities, for example, grounds of discrimination in 15 and 16 being different? And what about the complex relationship between Article 14 and Article 15? And again, I would also draw the point. I mean, if you compare the American Supreme Court decision on reasonable accommodation vis-a-vis states, and the Indian Bombay High Court decision, and for that matter, UPSC decision of the Indian Supreme Court on reasonable accommodation, then it appears that Indian courts have fared much better. So don't you find that this is complex, and therefore we cannot perhaps look at Indian discrimination law from the prism of comparing to constitutional law? Will it be simplistic because of the particularities and distinct semantics of the discrimination regime under Indian Constitution?
Thank you. That's very interesting. There's a lot of questions. I'm not sure I can answer all of them But let me answer the broad question first, which is that, and it's in some way that repeating Cheryl's response to the previous question, which is yes, Indian law is complex and has its own indigenous growth, but that does not mean comparative law is not useless. I think you are absolutely right on disability. Now, it's because my time was running out, I could not really talk about the disability discrimination dimension. I think that's been, and of course there are huge problems with the Disability Discrimination Act and the recent bill that's being discussed. It sounds like an improvement, but I haven't looked in detail to see how much of it. But that is a success story in Indian discrimination law, to the extent that you have a civil law regime to deal with private discrimination in certain limited contexts, and that must be part of the story when told in full. So you're right about that. I think, but that does not, I don't think, is a sufficient answer to the pathologies in the Indian system that I identified. On your particular questions, the tension between only and or any of them is absolutely a key one. The Supreme Court has taken only very seriously in Article 15.1 and has more or less ignored or any of them, as if it wasn't part of the clause at all. That is the short answer, and basically it's the use of the word only that the court has relied upon to use a highly deferential standard. Every sex discrimination case that goes to the court says this is not only on the ground of sex, this is also because Indian women bear child caring responsibilities or don't necessarily work. Yeah, that was the reason why sex discrimination was prohibited in the first place, right? So the way the word only has been read is to emasculate Article 15 from its potential. Just a quick word on one of the other questions that you raised on the 14 and 15 relationship. Just a little piece of information on the drafting history. So when I mentioned there was the slaughterhouse cases in the US which brought equality and non-discrimination together, I think the specificity and the chanceness of that interaction must not be lost sight of. The draft Indian Constitution did not put 14 and 15 together. 15 was an independent Article 9, which was a self-standing guarantee on discrimination. That is what the framers mainly debated in the Constituent Assembly. 14 was the second part of what is today Article 21 in another part of Part 3. It was an afterthought to put them together, and I fear it was an afterthought after some conversations with an American constitutionalist that put them together, right? So today, what we have is 14 has expansive deferential jurisprudence, 15 is a facet that doesn't do very much if it does anything. So that's a response that I suppose I could give in the short time available.
Thank you. Now we have a number of questions. Firstly, the young man here, and then afterwards, please, and then here, then this is after that. So you can take them in order. If your question relates directly to the question that comes before you, could you please let me know, and then we'll try and take them together.
Hi everyone, my name is Yasir Abbas and I'm a PhD candidate here at NLU Delhi. We have this concept in India that judges cannot make laws, and once they engage in cross-border constitutional dialogue, there's a tendency that they may incorporate a new legal doctrine within our constitutional jurisprudence, and by virtue of doctrine of precedent, it also becomes the law of the land. And the problem is that since judges here are not elected, this incorporation of new legal doctrine lacks the democratic legitimacy, unlike a law made by the legislature. So that's one question that I have always tried to answer but failed to. So maybe the panel, anyone from the panel can help me figure it out. Thank you.
Look, it comes back again to what Nick was describing in his very sort of careful unpicking of the various judgments to what judges actually do when they refer to foreign law. I think it is true to say that judges between different courts do it differently. So I once engaged in a very interesting experience comparing the way in which the Courts of Australia and the Courts of Ireland referred to foreign law, and I realised that the Courts of Ireland took a much more universalistic approach to it than the Australians, who are a bit inclined to pick away and look at context. But none of them ever regarded as binding. They never treat it as local authority, and the doctrine of precedent is never engaged. And more often than not, it's used at various other points in the reasoning, and you know how complicated our judicial reasoning is. You know, at some point where you're framing the issue, you know, what is the question to be decided here? Or at some other point where you're looking at options, or at some other point where you're considering what would be the consequence of going down this path rather than that path. There's all sorts of points in the very discursive judicial reasoning that our system encourages, at which foreign experience of some kind can become relevant and can become a very useful tool in order to reach a domestic answer.
Yes, I mean, I very much agree with what Cheryl has said here, and indeed, well, Cheryl is too modest to say it, but I mean, she's made this argument in print to the extent of arguing that one of the issues in common law reasoning, in fact, you know, is that the court is anxious to rely on sources which may be of help to it, and it is easier for common law courts to do this very often than for civil law courts to do. And as a result of that, it shouldn't be terribly surprising that courts are engaging in the process they are. Now, I think I'd add to that a further comment, which is that, I mean, like many people, I think it is unduly simplistic, whatever jurisdiction one is in, to, at least if it's a common law reasoning-based jurisdiction, to assume that the courts are bodies wholly separate from the legislature and vice versa, in the sense that the legislature makes law, the courts merely apply it. I mean, we obviously all know that the legislature creates law in very general terms. It's then the job of the court to interpret it. In a system involving precedent, the court, of course, has to give its opinion on particular meaning, and that stands and develops unless and until it's overturned by the legislature. So to that extent, if you're going to say it's illegitimate for courts to use non-local authority when carrying out the development, I mean, first of all, you have to be assuming that they are using that authority in a very, very strong fashion rather than simply an informative way. But secondly, you presumably also have to be reading into the situation either the view that there's something inherently conceptually different about the type of authority drawn from the Indian constitution, which courts can use when developing precedent, from other sorts of authority, you know, and also the notion that there is almost a political status in having nationally rooted bases for arguments rather than more generally rooted bases for arguments. And obviously that second position is a much more sort of contentious one politically, but it does beg all sorts of further complicated questions about what courts may and may not look at. So for those reasons, plus the answer that Gerald has given me, I simply think it doesn't make sense to say you can draw a strict division between the role of the courts and the role of the legislature in developing law, and as a result of that, given the nature of common law reasoning, there should not be any sort of automatic bar to bringing into play other factors, so long as it's done in the right way.
Yes, please.
Myself, Neeraj from National Law University, Delhi itself. My question is primarily addressed to Professor Craig and the last part to Nick also. What do you understand that most of the nation states, when they undertook the task of framing constitution and all this, the primary document, in spite of recognition of many secular rights, there were certain things which were treated as non-negotiable and rights were subjugated to that. That is, some kind of carving out was done. And primarily considerations were based on defense and economy, that is finance. And to a larger extent, the cultural identity of a state also. These were the factors which were taken into consideration while giving effect to many so-called secular rights. Now, what I see, whether you talk about the judgment within the legal system itself or creation of a world forum, what you find that defense, finance, they are still respected, but the peripheral majority of any society, their rights are seriously curtailed. So do you think that that is the way forward? Thank you.
I'm not sure that's really my question, but let me make sure I understand the question properly, because I'm not sure that I think I missed the last part. So are you asking whether there's some commonality in terms of rights protection which should, as it were, guide us moving forward across jurisdictions? Is that the kind of essence of the question? Yes? Okay, thank you. I didn't want to be answering the wrong question. Thank you very much. Okay, so I'm still not sure I'm the right person to answer this, but in any event, I think a two-stage answer. One is to echo a point that was made earlier, which is that whenever we do constitutional law or administrative law, we're always looking at a balance between similarity and difference. And the balance between similarity and difference, or legitimate comparison and legitimate difference, people may take a different view about what that actually is, where the dividing line is. But one of the ways in which I would put it is to use the old Dworkinian distinction between concepts and conceptions, which is that, fine, the higher the level of abstraction at which you take protected rights, in inverted commas, as a concept, other things being equal, the more commonality and agreement that you'll get between legal systems that, sure, yes, of course, at a high level of abstraction, we believe in a right to life and a right not to be tortured and that kind of thing. The more detailed you get into the more particular conception of freedom of speech, the more particular conception of discrimination, the more particular conception of freedom of association, the more room you get for difference of opinion and legitimate difference of opinion, which may be grounded in the culture and traditions of that particular society. So I think that would be my take. We can still, I agree with everything that was said in relation to the answer to the previous question about our capacity to learn from and draw inspiration from other legal systems, albeit in a measured way without in any sense taking it as precedent. And I agree, I'm one of those people also. I'm not a sort of radical pluralist. You get some people out there arguing that, well, there's no way in which any legal system can really borrow anything from any other legal system. I don't buy that at all. Nor do I buy the idea that in some way there are, you get another version of radical pluralism which says, oh, well, all these are just Western values. I don't believe the people that the idea that you shouldn't be tortured is a particular Western value. I think if you actually ask people in any part of the country, in any part of the world, do you want a midnight knock at the door? They'd say absolutely not. No, of course we don't want a midnight knock at the door, and we don't want a police state, and we don't want people pulling out our fingernails. So, the idea, that kind of radical pluralism which says, values and rights which we regard as a cornerstone of a liberal democracy are somehow untranslatable and untravelable, I think is a fiction. But at the same time, once you move from concepts to conceptions to more particular detailed conceptions of the rights involved, you get more room for legitimate difference.
Sure, yes, just a couple of things, really. Certainly like Paul, I'm certainly not in any sense a believer that, yes, things can't be, that there aren't certain things which we all have in common, as it were. Equally, I don't believe that there are sort of rigidly defined common norms down to the very last level of detail. don't apply taking societies forward across the world. Clearly there has to be room for interpretation. But then it is, as Paul is saying, always a matter of degree. I mean, I think what's interesting here, say if we think about the position in the United States for a moment, is even Justice Scalia, who obviously doesn't like non-US evidence or authority coming into play when talking about the interpretation of the US Constitution, was perfectly willing to accept, in a dictum in a case called Prince and Mack against the United States, that while it was inappropriate to the task of interpreting the Constitution to use European case law, it was of course quite relevant to the task of writing one, which is, fine, a fairly bland statement, but clearly at least he is acknowledging that countries, when they are established or when they draft constitutions as a fundamental statement, are likely, just as an empirical fact, to rely on values drawn from elsewhere as well as from domestically evolved notions. So if somebody as sceptical as Scalia is taking that into account in the drafting of constitutions, there, clearly that would suggest there is some room for commonality. Just on the point about interpretation, though, I think an interesting issue there would be, unless we are shifting back to the position which once prevailed in common law jurisdictions, of assuming that interpreting a statute or interpreting the common law just meant reading the text and trying linguistically to deduce what the terms in the text meant. Unless we're going back to that very, very artificial way of thinking about how we do things when we interpret, then the ability to block a wide range of ideas coming before the court is presumably pretty narrow. So in that sense, it is probably more reasonable to expect that the court will take into account a wider range of ideas, values, etc., just because all of those things are out there in society. And it's inevitable, as in the Naz Foundation case, that the council concerned will come along and present them to the court.
Can I just add another point that was prompted by Nick's observations about Justice Scalia? There's another exchange which was extrajudicial between Justices Scalia and Breyer about the use of references to foreign law. Justice Scalia being a foreign law skeptic, as you know, Justice Breyer being someone who's prepared to use it. And in the course of this exchange, Justice Scalia says, well, of course look at foreign law, just don't say so. Now, frankly, we're so used to a tradition of reasoning where judges do say what their reasoning is, and then we can all pick it apart, that's not my preferred solution. So I would rather judges came clean as to what they were doing, at least to that degree.
And I think Taryn has a comment as well.
Yeah, just to flag some Professor Bakshi's work in this regard. There is also an Indian story to tell you where there is in India the idea that we should not look outside for ideas and inspirations is a particularly un-Indian idea. That India itself has had a long tradition, colonial and post-colonial, and the transition of looking and borrowing and of course, how you do it, where you look, how much you look has been long debated, but India has been involved in the framing of these universal declaration norms, which gives even less credence to the idea that Paul was attacking, that these are Western norms, etc. So apart from the general comments that have been made, it's particularly untenable in the Indian context.
We have a question here.
I'm Shirish Deshpande. Actually, Paul Craig has already answered my question. But nevertheless, I would like to conceptualize this autochthony thing as a recovery of the sovereign power. To look at the situation where, for example, the Bills of Rights are almost globalized, and the regional experience in European Court of Human Rights and European Court of Justice is another example of regionalization of human rights. So there is some kind of shifting of sovereignty from the national legal system to the supranational legal system. So I think this particular autochthony principle which you are talking about, first of all, it is a recovery of sovereign power, and secondly, through that assertion of power might be to identify or to develop some identity of your own. This is my comment. Thank you.
I think we have a question which is identified as being the same vein. So sorry, Professor Singh, so patiently waiting here.
This is, I'd sort of frame this as a comment for everybody. The previous question sort of alluded to the notion of sovereignty, and I mean, I don't have anybody specific to put this to, but I think all your projects speak to the political as well as the legal notion of sovereignty, and maybe if you could say, if you think it's interesting to sort of react back and say that maybe how your projects react, and take on various notions of sovereignty, and well, that's
including judicial power.
Yes. Everyone at that question. There was a question to discuss sovereignty. Who would like to take on those?
The questions are directed, I think, both, well, the first one was directed, I think, at me, Shirish's question, and I think the second one was directed at the whole panel. Very briefly, my response would be a twofold response. Firstly, in relation to the way in which Shirish put the question, I mean, I haven't thought about how far I would conceptualize this as an exercise or a manifestation of sovereign power. I think that's a very interesting way of putting it. But what I would say, my initial intuitive response, is that even if one wishes to conceptualize these strains of autochthony as manifestations of sovereignty, putting it in that conceptual frame is forming a conclusory function, is not giving you anything ex ante at the front. And what I mean by that is that you can rationalize any answer you want to give in terms of, oh, well, we have a thick or thin conception of autochthony, and then we express that as a manifestation of sovereignty. But it doesn't give you, so in that sense you can express it in conclusory terms. But I don't think that the sovereignty idea gives you any ex ante tool which, as it were, allows you to predict or preordain how thick or thin the conception of autochthony that legal system is going to work with. So I think that would be my response, Shirish, to your very interesting question. I mean, my very brief response to the, or my own take on the second question, from the perspective of my paper, is that I think one of the things which is interesting, which is one of the points I did make when giving the paper, which is not provable in any easily methodologically convincing empirical sense, but which I think nonetheless strikes a chord for most people, is that you're getting put, while we live in an increasingly globalized world, and I'm particularly aware of this, having done a lot of research on global administrative law, more recently in global regulation. While that's true, one of the manifestations of that is people questioning even more so the way in which these norms come into their system, and the fact that the norms may be made out there in the global world, in the global arena, by the WTO or the WHO or some other such body, but they're made in ways which don't comport with the way in which regulatory norms would be made back home. That in itself then causes scholars and politicians within legal systems to say, well, wait a minute, we built a whole set of protections for norms of this kind when made here at home, and suddenly they're being parachuted into us and dropped on us, and they've been made according to a different set of criteria. We think that that may be rather worrying, and therefore you get these, what I call different strains of autochthony developing, partly as partly the catalyst being the increased globalization and a defensive reaction there too.